allowed to ask during that last session. So I'll make this quick. I'm going to shift gears a little bit here. So did any of you have any input in crafting of the amended pay-to-play ordinance?
Okay, I'm sure we all did. I don't know specifically going back to, I guess it was back in January or February when we started, probably informally talking about. I will say that the mayor probably had the most input because he knows more about it than, quite honestly, myself. The different ordinances and.
So it was discussed.
Believe it or not, before we get up here, we know what we're going to be talking about. Yes.
And what was the communication method? Did you talk on the phone? Were you emailing each other?
Probably on the phone, or sometimes just back then. Probably at before the parade. I'm friends with Matt, and we talk to him, and I see him around. I can't speak for the other council members, but on the phone I talked to him. He called me at school today. Back then, probably on the phone, walking the streets, whatever. Maybe he came over to the house.
Okay.
Yeah.
So you did discuss it outside of this chamber.
Yeah.
And when it was created, when you saw it, you all read it, I assume, correct?
Sure. It's always
Before you voted on it, you read it?
Yeah.
Yes? Okay.
We voted on it.
There's no test, I'm not gonna
No,
question.
I know, but I mean, just question.
So you did read it, okay.
You do read it.
Yeah, I read them too, it's complicated, it's a lot of
Very
legalese, and
complicated, yes.
did you have any questions about it?
Sure.
And did you discuss those questions
I'm sure we did.
with each other?
We have to be careful here that our answers aren't misconstrued to be a violation of the Open Public Meetings Act.
Okay.
Which is my guess where this is going.
Yeah, and I'm not
Well,
understanding.
thanks a lot, Joe.
Well, I do too.
Let them answer.
Yeah, I just want them to be careful in their answers and not give answers that can be misconstrued.
But it's also very hypothetical, like then and now and when and back when.
Yeah.
So discussing it outside of these chambers is hypothetical, or you did?
I'm sure we talked about it,
Okay.
one-on-one.
So you had some questions about it, I assume, before you voted on
I'm speaking for Brian McGovern. Yes.
it? Okay, well,
And
you guys
before
can
we-
answer too. The other
Before we
ones-
vote on it, I'm sure we were presented with the ordinance that you present. Anything that comes up, we get information from the administrator. That's our role as administrator.
Okay.
We read through it.
All right, so you read it before you voted on it, you had some questions about it, so you talked amongst each other to.
Well, wait a minute, that's where you wanna go with this, and that's
It's like
not
we
what
got,
they
it's not like
said.
we huddled in an alley and had a discussion. We
There's
didn't
no
do it.
requirement that they discuss it with anybody.
Did
They
they
look
though?
at it like anybody else and they vote upon it. They have questions they could ask me, which, I know,
Yeah, that's true.
I answered questions, from at least one council person. I'm not gonna go into my communications with them, but I mean, that's one way. Another way is you could ask, the VA, but I'm not certain that anybody had any questions. I answered some, but, I mean, other than, if you're looking for a meeting that we had and we
No,
discussed this.
I'm
that's
just
not-
curious about any kind of discussions that took place.
Okay.
So there were, I guess. So when the,
There were, you want that to be, that they had.
I'm just
discussions.
taking what Brian said at
I
face value.
know, and then at the end you say, well, there were discussions and then there's no comment, so then it looks like they're acquiescing to your suggestion, so I just wanna bring that out, that they're not.
Duly noted. So when the ordinance was voted on and passed unanimously, and then the inevitable happened, a petition was circulated and submitted with over 300 signatures, did you guys have any input in the hiring of the law firm to review the ordinance to see if it was, do you want me to ask George?
Yeah, I'm gonna defer to George. I mean, I don't think we're in the position of selecting attorneys.
So you guys didn't have any input in that?
Whatever input they would have would have had to be in public, and they didn't have, did we have a vote to
The
hire?
attorneys, Gretzky and Hollaback, was appointed by this council at the reorganization meeting in
Right.
January, specifically for the purposes of potential litigation.
So when the ordinance was given to them to review, whose idea was that?
I'm sorry, is that a question to me?
It's a question to whoever can answer it.
I don't, say that again?
Yeah.
When the decision was made, after the petition was submitted, to give them the ordinance to review the constitutionality of it, whose decision was that?
Isn't that the process? There are attorneys.
If I recall, I had a conflict with that because of my prior employment.
Yeah.
Right.
And I'm not certain how, I think I said that I
I do recall that.
well, I don't know what, I don't wanna say I said anything, I know I couldn't do it, we just probably sent over to the conflict council.
Yeah.
I think
So-
that's the way-
This wasn't last week, this was back in
I don't know.
January,
It was
February.
actually
Your,
March.
your memory might be great, but.
Well,
you
it's
know,
all
the
a
question
matter
is,
of public
I may not
record.
Remember, 9 months ago.
You can look it up, it's
Yeah,
public.
I think that's pretty much it, I mean, when I came in, it was understood that I would have a conflict with that issue,
Okay.
So we don't know who made the decision to have them review it? Is that the answer?
They were our attorney, right?
Likely mine is just,
So it was your decision to have them review it?
it's quite possible that Mr. McGill and I had a conversation and I referred it over to conflict counsel.
Okay, we don't wanna turn this into debate.
Okay.
I don't want, your 5 minutes is up, so. I'll give
My
you
5 minutes is up?
Yeah, you get 5 minutes, and as I explained, everyone gets 5 minutes. If we can answer your questions, and I think we've been trying our best to answer your questions.
I think
Some
you've
of
been
them are
trying your
a
best to avoid my questions, I don't know about answering
Still
them.
makes
No, no,
sense.
we're not a-
It's difficult.
Well,
Very
We're not
repetitive.
avoiding your questions, we're trying to get you professional answers by going to our attorney and to our administrator of a question you're asking that happened 9 months ago. I think you've probably been studying your questions and know exactly what you want to say or what you want to hear. I don't
know
think
what I want to
you're hearing
ask.
what we're saying.
This
You're
is
asking
all a
questions.
matter of public record.
It's like, where were you on the night of the 12th?
No, it's not. No,
It
it's not.
is.
This is a very big deal, and you guys are all kind of playing the shuffle game
No,
here.
we're not, your
Okay.
questions are very hypothetical.
They're not, they're direct
Okay,
questions.
everyone's given 5 minutes, there's other people in the room that want to speak. Thank you.
Thank you.
Yuri spoken. Mr. Kirschenbaum, again, I'm gonna repeat, 5 minutes. If we can answer your questions, we will. If we can't, then we'll try and get you the answer at another time, but 5 minutes at the microphone. Yeah, go ahead.
Mr. Montgomery and the board, I'm the gentleman you alluded to that brought up
I knew
the
that.
revaluation. Maybe the audience doesn't know it. I'm not in one.
Correct.
I'm not here to hurt anybody. But just like you said, 116-year-old home and they put depreciation. Well, yeah, but my experience with the company was basically the guy wouldn't listen to me, threw his hands up, said, "You beat me up," and left. So I got no satisfaction at what they call the informal hearing. In regards to my house being 116 years old and that 116-year-old house next to it, they put amenities into it. Your tax assessor says there's depreciation, but there's also functional obsolescence, durable depreciation. There's other things you gotta look at in a home besides the cost approach. And he says that we're mandated by the state for the cost approach. And I think I read this before, but it basically says, the courts have determined, indicated the result of a single approach is in itself not to be considered an absolute detriment of value to the true value of property, but whenever possible, all three approaches should be used in the final determination for the value for tax purposes.
Mr. Kirschenbaum, was that in a revaluation setting?
This,
It sounds like you're citing from a case.
this is a letter, I asked a question about my house on a revaluation, and Judy P. Miller, Chief Property of Administration Division of Taxation sent me this letter, because I had a question on the approach they were using.
Right, because, you know, generally on a tax appeal, I'm not talking to reval, because Ed said that the cost approach is mandated, and then seemed to say that it left it to the, property owner to then challenge it, and then when you do challenge it, you can challenge it on comparable sales. So, you know, I'm just trying to understand, you know, what we're talking about.
This isn't my 5 minutes?
You can do some more time, I don't mean to take it from you. Go ahead.
My question to the board, when you say cost approach, that's exactly what it means. And the way it was explained to me by Norman TK, Realty Appraisal, was they take the square footage of the house, square footage of the land, they put where you live, and out come the cost of materials and labor if your house burned down. That's basically what it would cost to build your house in 2016. I'm saying that's not where you can get the fair market value. And if everyone is mandated in the state to use just the cost approach, I've got 6 contracts here from different towns. They all say the company agrees to appraise all properties using the 3 approaches to value where applicable and to use acceptable method, forms, and manuals authorized by the New Jersey Division of Taxation.
When our tax assessor was up here during the workshop session, he said the state Supreme Court mandated the cost approach. Now, if you go to appeal, the courts allow you to use those 2 other ones that you use. So, yeah, you can use all 3, but the company that comes in to reevaluate your house uses the cost approach, which was mandated by the court. That's what they're saying. That's, I think, where the confusion might be.
I called the Deputy Director of Division of Taxation, Patricia Wright, last week. And I said, is New Jersey State, are we mandated to use the cost approach? And she basically said, and I don't remember it word for word, that basically the Division of Taxation cannot mandate a town on what approach it uses. The town itself chooses what approach.
Well, I think we have a, he said, she said, because our assessor told us, and our CFO said clearly, stated, that it's been mandated by the Supreme Court of, Superior Court or Supreme Court of New Jersey?
Yeah, I don't know what case it was, they said Supreme Court first, then they said Superior Court, meaning the tax.
So,
possibly, so.
I think they have to go, and they're requiring the company that's doing the reevaluation, not the homeowner. Once the reevaluation, as I understand them to say, that when you get it in the mail, and you think it's too much, you can appeal, and you can go and use those 2 other approaches that, to get your
Mr.
price.
McGovern, in my experience, that most people, once they get the revaluation letter, they really don't know how to use the Mod 4 system, or how to fight back, how to get comparables. I've seen people that, they just get thrown out at the county, and when I went to the county, they had out-of-date comps, and they didn't throw them out. I come to find out, if you're a taxpayer, and you ask the town, county, or the state, comparable sales, where you're allowed to go back to, it's the pre-tax year of October 1st,
Okay.
which for me was 2014. But the appraisal company is allowed to use market data that goes back 3 years. Patricia Wright told me she didn't agree with her assessment. And she went to the tax court. And what she said was, she said, the judge told her, you cannot use non-usable codes and out-of-date comps. And she says, hold on.
Okay, I can't go to third party what this lady told you.
Okay.
And your 5 minutes, you know, we listened to you.
Okay, can I just read one thing though?
How long is it gonna be? You gonna read the whole page?
No.
Okay.
There was a town that used the cost approach years ago, and a gentleman sued. And basically, the judge says, and it made case law, that the, it has been shown on a number of occasions that cost is not value, and the gentleman won the case. And the town that was in was the borough of Belmar. They made case law.
Was that a revale case though? I mean, because there's always a choice between which method is best. You know, so in certain circumstances, one or the other is gonna be best. Cost approach is a valid approach in certain circumstances, and Ed Mullane said that the revale is required to use that. So, I mean, I can't sit here and say Ed's wrong, or
No,
you're wrong.
okay.
I mean,
If you use the cost approach,
Ed's the expert.
there's other factors that bring down a house, like you said, depreciation
Yeah, I think
and
I
everything.
think some of them.
But I heard Mr. Brennan say that it's nice to know his bathroom's worth the same as a house in Rumson. Am I correct?
Probably thought, because I was thinking.
But
But
Sure, Janice?
The guy was there at my house, yesterday, I think it was. He went into my kitchen and he said, "Ooh, old kitchen," and wrote that down. The house is 84 years old. He noted that the kitchen was old. So he asked if I had central air conditioning, which I just laughed at because it's impossible to put it in. So he noted that. So it's not just taking, to me, it was not just that he's taking the square footage
see,
of the house.
you had a
He's
good
bringing-
experience.
I felt it was a very good experience because my second floor, I've got 1.5 stories, so my rooms upstairs are not full rooms, they're attic rooms, which he wrote down, they take that into account to bring the value down. It's not just the square footage
See,
of the land and the house.
the guy never wrote anything down in my house. It was through it in 5 minutes, and that was the end of it.
Well, he was there about 10 minutes and he didn't write anything down, they're now doing it all on an iPad, but he had information in there and he was putting other information into the iPad. So, that was the experience I had just yesterday.
Okay,
Thank you, Mark.
thank you.
Katrina?
Train flaps at B Street. Beside your, discomfort with the, mailer that came in about the special election, I'd like to ask you guys a couple questions about it. I really would like your independent, individual opinions about the overwhelming turnout and the fact that overwhelmingly the town of Belmar rejected your and Mayor Doherty's changes to our existing conflict of interest laws. No one has an opinion?
it's not time for
Yeah.
that. This is for you to express what you need to express.
Oh, okay, so you can answer some questions, but not others, right?
Well, that's what we said, we could, if we can answer you, we can, if
What
we
would you like
can't.
us to say?
Well, I would like your opinion on it. I would like to see how
There's
you
a low
do.
turnout and the
A
number.
low turnout,
went through.
1,200 people is a low turnout.
Yes, it was.
But same as the pavilions last year, which our mayor then touted about, he won by 17 votes and how wonderful that was.
I don't know about that.
No. Okay. Mayor Doherty is quoted in the Co-Star as saying, "We are appealing." And when Matt says "we," does he mean you, all of you?
We'll have to ask him.
You'll have to ask Matt.
You'll have to ask him.
I didn't read that article, I don't know what he said, but you know,
Okay, then here's my question. Are you, council people, planning on appealing and continuing, in this endeavor?
that discussion has not
Wait,
come up.
we're not gonna discuss litigation at this point.
Okay.
And I understand your question, but we're not,
Okay.
that's gonna be a discussion that we're gonna have.
Another time?
And with the appropriate counsel.
Okay, so can I ask a question about that? When do you discuss that and who discusses that? Is it in an open public forum? Or do you have a
Litigation,
meeting?
that would probably be subject to a closed session.
A closed
To decide
session.
what to do as far as moving forward.
And the closed
I was
session?
saying, okay, I'm thinking off the top of my head, and I think that's the way it would go.
Okay.
Because
You-
whether or not, we're gonna engage in litigation, yeah, that would be subject to a closed session.
Okay, and the public would be made aware of that closed session?
The process is that after time has passed, not so much time is required, but when it's appropriate, meaning that it can be released, it will release the minutes.
It's public notice.
So in other words, at that closed session, minutes of that closed session are taken,
Okay.
correct? And then they could be made public, at the appropriate time,
Yeah,
right?
and, you know, as far as the decision of, you know, whether or not it's gonna appeal, that probably wouldn't be a secret for too long, because you have to take steps to actually appeal.
Right, so here that kind of, I'm a little confused about it, because if I'm not mistaken, Matt Doherty, where is he, by the way? Does he ever come to meetings anymore? When? He was
They
at
said
both
I'm doing
meetings
such a
since
good
May.
job that,
Yeah.
indeed,
Well, no offense, but we didn't vote for you for mayor.
I, neither did
Matt's
I.
our mayor.
I didn't
He
vote
has
for
something
myself for
here.
mayor.
But anyway, wasn't Matt instructed by borough attorney, for conflict reasons not to participate in votes on ordinance 2016-01 because it directly benefited his freehold run? And if he's disqualified from having an opinion, how then can he have an opinion on the appeal?
Well, when he's talking to the paper, it wasn't official, right? So
No, he's
What wasn't
entitled to his
when he
opinion.
speaks to the newspaper, it's not an official opinion. I guess anyone in this room can have
I
an
mean,
opinion.
can he vote on,
What-
if
what
you guys
are
are
we
gonna have a
talking
closed, I
about?
wanna know if you're gonna have a closed session, if Matt Doherty is gonna be involved in a closed session making the decision, or are these four people gonna make the decision?
What
Of appeal.
what appeal are we talking about?
I don't know, that's what our mayor said,
Oh.
we're going to appeal, and I would
Well-
like to know what our mayor was talking about,
Oh, okay, then I don't know, he's not here.
Yeah.
And,
which is my point exactly.
He didn't talk to me of what he said to the newspaper, so I can't answer.
Well, wait,
Uh,
we don't know what we're talking about as far as appeals concerned, so, I mean,
This
Mayor
wasn't-
Matt said in the co-star interview that you were gonna appeal the judge's decision. I don't quite understand it myself, which again is why I'm here, because I don't quite understand it.
Okay.
Which
That's
leads
what-
me back to our council.
that's simply what Matt said, though, you know, that's not what anybody here said.
Yeah.
I don't have to
Okay.
speak for them, it's just,
All right, okay.
something was reported in the paper, you're asking a question, it's valid, but
All right,
They
so,
can't answer.
all right, let's say that they can't
Okay,
answer.
Judy,
I'd
you have
like-
another question, because your 5 minutes. I
It's
know we
not
were
quite
talking
up
back and
yet.
forth.
I would like to know, I would like to say that back at you, that you guys can withdraw the appeal that's in place, and you can save thousands of dollars in legal fees, contrary to Matt's misleading letter before the election. The judge has already ruled that the borough is responsible for both the borough's and the plaintiff's fees. You have the power to stop wasting taxpayer money, and it is your responsibility to abide by the overwhelming support of our current conflict and pay-to-play laws.
Thank you.
Thank you.
Yes.
Hi, Amy Faithorn, River Avenue. I'll be quick. I just wanted to mention, because I know there was seemed like a lot of animosity here in the conversation between Tommy and my husband and you. And I just want to say that he was not trying to trap anybody. He just wants to understand, just because of the timeline of it, you know, having an overwhelming no vote and then the appeal, that is supposedly happening. So in thinking, you know, geez, you know, if the appeal wins, what don't we understand about this that we thought maybe we did? So he was just trying to look back and, you know, see, is this unconstitutional? Is that the reason it was brought forth to be changed in the first place? Things like that. And so he just wanted to understand fully. That's all.
Very good.
Thank you.
Thank you, Aileen. Jim?
Just one real quick question. It's gonna be reference to the church, the curbs and the sidewalks. I know way back when I came to Belmar, put our name on the list for the sidewalks. Our curbs are all the old slate curbs, and they've all sunk and twisted. Will they be replaced?
You could certainly get a quote from the contractor when they come around, so we'll make sure that we have your information. I would come to one of the informational sessions, and you can talk to the contractor directly,
So curbing is not included with the sidewalk replacement?
because the sidewalk is accessible.
Okay, thank you.
Okay, definitely come to a session.
George?
Oh, no, I was waiting in the gym, but he didn't see me.
Okay. Okay, seeing no other hands, I move to adjourn the meeting.
All in favor?
Aye.